Okay, so we're ready to get started. First of all, welcome to our Smart Counsel webinar. Thank you for coming. I'm attorney Suzanne Sayward, a partner at the Dedham, Massachusetts law firm of Samuel, Sayward and Baylor. And with me today is one of our associate attorneys, Megan Bartholomew. And for those of you who aren't familiar with our firm, we concentrate our practice in the areas of estate planning, which is helping people to create their wills and trusts and powers of attorney. And then we also guide families and fiduciaries through the estate and trust settlement process when someone has passed away. And so tonight's program is going to focus on that second part. What happens when someone has passed away, they leave a trust, and now the trustee has to administer that. A trust is a very popular and useful estate planning vehicle because it can address a lot of issues that people want addressed, like avoiding probate, maybe estate tax reduction, protecting inheritances for children, protecting assets for young children or disabled beneficiaries. So it's a really excellent estate planning tool. But once you've set down all of these great goals that you want your trust to achieve, then it's up to somebody else to execute it and make sure that those goals are achieved. And so that's what we're going to talk a little bit about tonight, the right way to do this and the wrong way to do this. You know, serving as a trustee is a really big responsibility. There's a lot involved in getting it done, and there's things that can go wrong if you're not paying attention to what you should be doing. And there's also liability associated with being a trustee, meaning that if your trustee doesn't do what she's supposed to, then the beneficiaries have recourse against her, and she can be liable to them for damages and can be removed, and it can all go very bad. So we don't want that to happen. So tonight's program is a little bit about how to do it right and how to do it wrong. All right, so Megan, why don't you put up some slides? We're going to take you through a series of slides tonight showing two families and how their trustees approached this process. All right. So take us to the next slide, Megan, where we'll introduce our families. So we've got our two trustees are Carrie Careless and Deborah Do-Right. They're in both of them are in Massachusetts, so that's what we're talking about here. And why don't you go to the next slide, Megan, and we'll see a little bit more about these families. So they're very similar. In both families, there were two parents. They each had 3 children, and both of the parents during their lifetimes created an estate plan, which included a trust. Sometimes we call that a trust-based plan. And in those cases, the trust is the centerpiece of the plan. And around the trust are what we sometimes refer to as the ancillary documents. So very important healthcare documents, your healthcare proxy, will, of course, durable power of attorney. But when you have a trust-based plan, it is the trust that's the centerpiece of the plan. And when someone passes away, having created a trust, it is the trust that includes all of the instructions for how to administer the estate, where it's going to go, what should happen, who's in charge, all of that. So in our two families now, Carrie Careless is the successor trustee of her parents' trust, and Deborah Do-Right is the successor trustee of her parents' trust. That means when the parents passed away, these two step into their shoes as the manager of what is in the trust.
And so similarly to the fact that both families have a similar makeup, they also have similar assets. Each family has a primary residence worth $1 million. They have retirement accounts worth $200,000, investment accounts with about $400,000, 4 different bank accounts totaling 100,000, and then some tangible personal property, some stuff totaling about 40,000 for a total of $1,740,000.
So before we move on, one of the things to be aware when someone is settling an estate is that the trustee is only in charge of the assets that come into the trust. So in our families here, where both had an IRA, we're going to assume that the parents had named the 3 kids as the beneficiaries of that IRA, and the trustees don't have anything to do with that. Now, that may not be the case. In some families, the IRA may go into the trust. But the important takeaway here is the trustee is only has control and responsibility over assets that come into the trust. So in our scenario, everything else is in the trust except for the tangible personal property. And as Megan mentioned, that's the stuff, their cars, their furniture, jewelry, etc.
Okay, so now both sets of parents have passed away, both the careless parents and the do-right parents. And so now it's Carrie and Deborah's responsibility to step up and serve as the successor trustees. And they're each going to perform those roles very differently. So Carrie here, she thinks that she can do this all herself, and that if she doesn't hire an attorney, she's going to save some money. And so she thinks that pretty much she can figure everything out by looking it up online. She has a friend who's an attorney. He's a personal injury attorney, but she just assumes that everyone who is an attorney can, do pretty much the same thing and will be able to help her out. Carrie, before their parents passed away, she was appointed as the attorney in fact. And so now she thinks that she can continue to use that durable power of attorney to manage her parents' estates. However, as Attorney Sayward mentioned, the power of attorney doesn't control trust assets. It only controls assets held in the parents' individual names without a beneficiary named. And the power of attorney also dies with the parents. So once the parents have passed away, that ceases to be a valid document, and Carrie's not going to be able to use that to access assets, even if they were in her parents' individual name. Because Carrie assumes that she can use that power of attorney, she doesn't look up any type of trustee paperwork and doesn't take into account what she's going to need to bring with her to the bank. So when she shows up at the bank with that power of attorney, they tell her, sorry, you can't access these accounts, and you're going to have to go back and figure out what type of paperwork to bring with you next time. And in addition, Carrie really just doesn't have an idea of what kind of assets her parents had, but she also doesn't know who they were using as their accountant. So she just assumes that all of the assets she's aware of and able to see, that's the entirety of her parents' estate. Deborah Do-Right, on the other hand, knows that this is going to be a lengthy and confusing process and needs someone who is going to be able to walk her through, tell her about her role as a fiduciary and how to avoid liability, and also, what the steps of the process are, how to do this properly. So she hires an experienced trust and estates attorney, and then that person tells her that the first step here is that she should send these MUTC notices to the beneficiaries. And so these notices are written notices sent to the beneficiaries, notifying them that Deborah is going to be the trustee of the trust. It gives them her contact information, and it also gives them a copy of the trust and of the will, notifying them that they are a beneficiary and that they are entitled to a distribution. The attorney also notifies Deborah that once her parents passed away, their taxpayer identification numbers pass away with them. So the trust now needs its own taxpayer identification number to report income under. So Deborah's attorney is able to apply for that new taxpayer identification number and give that to her. And he also creates what's called a certification of trust, which now reflects that Deborah is the successor trustee. Deborah brings both of those documents plus the death certificate with her to the bank. And because she has the proper trustee paperwork, she's able to immediately get access to those the trust accounts, you use the assets as needed to pay bills or expenses, and to start managing the trust assets as a trustee. Deborah also contacts her parents' financial advisors and their accountants and asks them for the assets that they were managing at that time to get a clear list of all of the assets that she will be managing as the trustee.
Before we move on, I forgot to mention at the beginning that if you have questions, feel free to type them into the Q&A, and Megan and I will take your questions as we go along. So if we're on a slide and we're talking about something and you have a question about it, feel free to submit your question. Sorry about that. All right, so now we're on to the section called Read the Trust. It's amazing how often people don't pay attention to what the instructions are, and that's really what the trust is all about. The trust is saying to the trustee, okay, here's what you're supposed to do. You're supposed to marshal the assets, gather everything, pay the bills and expenses, file the tax return. Here's how you're going to pay the taxes. Here's the money you're going to use to do that. And then once that is done, you're going to distribute the assets in this way. So Carrie, again, without having someone to advise her, looks at the long trust and thinks, ugh, I don't want to read that. She assumes that her parents would just leave everything to Carrie and her two siblings and decides, well, that's just what I'm going to do. So she finally gets herself some access to the trust with the help of a kind friend who gets that paperwork together, and she starts writing checks out of the trust. Deborah, on the other hand, is advised by her attorney, who has reviewed the trust with her, that her parents, in fact, included some specific distributions to a couple of charities. So Deborah reaches out to the charities, notifies them with those notices that Megan mentioned on the prior slide. Hey, charities, you're a beneficiary under this trust, and you're each entitled to receive $10,000. So the charities are advised that they're going to get this distribution. And then Deborah, under the guidance of her attorney, sends the checks to the charities along with an acknowledgement form for the charities to sign off on, acknowledging that they've received everything that they're entitled to. And the reason this acknowledgement form is so important is at the end of this journey, the goal of the trustee is to have done everything under the trust as required, as directed, to have distributed all the assets as directed, and to have releases from all the beneficiaries acknowledging that they received what they were entitled to receive. That then means the trustee has done her job, and no one can come back against her and sue her in the future saying, oh, hey, I was entitled to some money and I didn't get it. So making those specific bequests early on is fairly common if the amount of the bequest is low. So we know that the do-right and the careless estates were a little over $1.7 million, somewhere in that neighborhood. And these two charitable bequests were each $10,000. So that's a modest amount relative to the trust amount as a whole. So if we were advising Deborah, we would say, yes, go ahead and make those distributions. If it was a much larger amount, or relative to the size of the trust, if the bequests were larger, we would probably advise the trustee to hold off until we have a real solid knowledge and understanding of what the taxes are going to be, what the debts are, because we don't want to have the trustee be in a position where she has distributed the assets only to find out, oops, there's a bill I need to pay, or there are taxes that are due that I didn't know about. So when we're advising trustees, our focus is always on making sure the trustee is doing the right thing and protecting the trustee. So we would advise caution on making large distributions quickly. Doesn't mean that they won't be made at all. It just means that we want to make sure that we have a really good handle on what's in this estate before we start sending money out, because the debts and the expenses and the taxes come first. So Deborah now is working on gathering all of that information, and it is a process. You know, it takes a little bit of time to get all this together. For those of you who are attending, I often will say to clients, the biggest gift you can give to your trustees, your fiduciaries, your family is to be really organized. You know, keep a file of what are the assets, what are the accounts, what bills do you pay on a regular basis? How do you get how do they reach these people? How do we reach your financial advisor? How do we reach your accountant? You know, so keeping as much information available in a place where your designated fiduciary can find it is a real gift to that person. It will make her job a lot easier. Even if the job is easy, though, it's still big. And so that brings us to trustee compensation and paying things out of the trust. So first of all, sometimes when someone passes away and the family doesn't have immediate access to money, then family members may pay expenses upfront, funeral expenses, you know, the luncheon expenses, maybe a couple of mortgage payments or something, but they are entitled to be reimbursed from the trust for any amounts advanced on behalf of these debts or expenses before there's access to the trust money. So that's for sure. Now, trustee compensation can be a little bit of a sticky area with families. Under Massachusetts law, it's very clear that trustees are entitled to be compensated, and trustee compensation in Massachusetts is based on really two factors. It's the amount of time that is spent on a particular task and the level of skill that the person brings to the task. I guess three factors, and what is the level of skill required by the task. So when we're advising trustees and other fiduciaries, we tell them, hey, you got to keep track of all the time that you spend working on this matter, whether it's sorting the mail or meeting with the lawyer or the accountant or putting the tax material together, staying on hold for an hour while you're trying to reach somebody to get access to an account. Keep track of your time. And then the level of skill comes in with, you know, who is serving in that role. If you have a family member who is, say, a lawyer or an accountant, they may have a higher level of skill in this position than someone who is not, who's not familiar at all with financial management or trust settlement. So they may be entitled to a higher rate of compensation than someone who doesn't have that level of skill. But that doesn't mean that say, for example, your trustee is a CPA, and now she prepares the income tax returns for the estate or the trust. She would be entitled to be compensated based on what she would charge anybody to do those returns. But if she's cleaning out the basement, she can't charge that same CPA rate for her time doing that because it doesn't require the same level of skill. So as a practical matter, what we do generally with non-professional trustees is come up with a sort of a blended rate, and we apply that to the time that they spend on trust matters. And I usually these days am advising trustees that rate is typically somewhere between, say, $35 and $45 or $50 an hour. Now, the other part of this compensation is that the total amount needs to pass the smell test, so to speak. So if somebody is administering a trust that has $100,000 in it, and the amount of time that it takes them to get things done times their compensation rate comes up to 50,000, that's not going to fly, as unless there was something extraordinary going on. As a general rule, the smell test means that the amount of compensation really should not be more than 1% of the total value of the assets that the trustee is administering, unless there is something extraordinary. And what might be extraordinary? Well, there's a lawsuit that has to be dealt with, or, there's a problem with the sale of the property. There's a title problem, or there's a Title V problem, or so there's something extraordinary that merits having this compensation that's higher than the sort of norm. So we advise our trustee clients, keep track of your time and be aware of this. So in terms of the trust distributions, in the due rights trust, as in the careless trust, there were these small distributions to charity. And then what these trusts said is, okay, once everything is settled and done, divide it into 3 separate shares, 1 share for each of the children. And these shares then were set aside for the kids, who could then be their own trustees and manage their own money, but it was not an outright distribution. So why did the parents do that? Well, the parents did that so that they could give their children an opportunity to protect the inheritance that they're receiving from the easy reach of the children's creditors. So something bad that might happen to the kids after the parents have passed away, like they have a business that fails, or they get sued, or they have a car crash, they get divorced, they become disabled. So any of those bad things that might happen, by having the inheritance go to them via a trust, it protects it for them and their future beneficiaries from the easy reach of their creditors. So we'll see where this can go a little bit wrong in Carrie's instance as we continue through our fact pattern here.
We have one question at the top.
Okay. Go ahead and read that, Megan.
It says, what is an MUTC document? So the MUTC stands for Massachusetts Uniform Trust Code. And that's a document that's required by statute to be sent to the beneficiaries within 30 days after the date of death, notifying the beneficiaries of who the trustee is going to be, their contact information, and that these people who are receiving the notices are beneficiaries.
So it's important that, one of the benefits of using a trust is that it's private. It's private to the rest of the world. But it's not supposed to be private to the beneficiaries once somebody passes away, and the trust at that point then is quote unquote set in stone, right? It's no longer a revocable trust. It becomes irrevocable at that point. But the beneficiaries then are entitled to know that they're entitled to a distribution or what their share of the estate is going to be. And we'll talk about that a little bit, a couple slides down.
And the next question is, how is trustee compensation reported for income tax purposes?
Excellent question. And the trustee compensation is ordinary income to the trustee. So the trustee is required to report that on her personal income tax return as ordinary income in the year she receives it.
So when you're serving as trustee, as Sue was saying, it's a huge role and it's a big responsibility. And as a trustee, you have a duty to be good at communicating with the beneficiaries, keeping them up to date about what's happening with the trust administration process, the assets that are held in the trust, and also to just be communicative to both the beneficiaries and to the banks or financial institutions that you're working with to do the administration of the trust. So Carrie here, she doesn't give any notice at all to her siblings. So those MUTC notices that we talked about that Deborah sent out a while back, Carrie didn't do that. And she didn't even tell her siblings that she was going to be the person serving as the fiduciary. So they have no idea who to even contact in the first place. Carrie doesn't give them any copies of the documents, so they don't have a copy of the trust or the will that they're entitled to. So they don't know what they're entitled to as beneficiaries. And then she doesn't provide them with any kind of accounting about what the trust assets are, because she really doesn't know herself, because she didn't get a big list of what the trust assets were. And so she just doesn't share any of that information with any of the beneficiaries. They have no idea how large the trust estate is, any way to account for what Carrie may be doing. There's no check for her there. Whenever they reach out to Carrie, she's ignoring the texts and calls. She's responding very infrequently. And when she does respond, she's doing it by phone or in person. She's not giving any written updates. Everything is verbal. So there's no written record of all the notices that she's providing. Deborah, on the other hand, sent those MUTC notices along with the copies of the will and the trust to each of the beneficiaries. She keeps a constant record of the inventory of trust assets that she updates as things change with the trust. She provides written updates to the beneficiaries. By statute, they're required to do it annually, but the beneficiaries can request information more frequently than that. And Deborah provides that information always by written form in either a letter or an email, always keeping track of all of the notice that she's provided to everyone.
So you may think that, you know, when we're talking about Carrie and what a bad job she's doing, that we're exaggerating, but sadly we're not. So, you know, of course, when we're advising people, we don't let that go on, but we get a lot of people who reach out to us who are beneficiaries of their parents' trusts or their auntie's trusts or something, who say, I have no idea what's going on. She never returns my calls. She won't give me any information. I never got a copy of anything. So those types of things definitely go on. And eventually what needs to happen, sadly, is the beneficiary ends up having to file a lawsuit in order to get this information. So when you're thinking about, you know, appointing your trustee, if you're thinking about doing your own estate plan and who would be a good person in this role, someone who is a good communicator, and I like to say who has some diplomacy and is able to deal with the beneficiaries and the siblings and, you know, make sure things are moving forward. Those are the qualities that you really want to look for. And if there's no one in your family who's that good at that, then you could look outside of your family, or you could really stress to your appointed individual, listen, it's super important that you get some advice, that you hire somebody who's going to do these things for you if you are not going to do them, because that's certainly something that we will often do. You know, we'll email the beneficiaries, here's what's going on, here's the inventory, here's what you can expect, talk to them about tax stuff. So we'll provide that, you know, that communication when we're advising trustees.
I think there's one question. Where does the trustee find the MUTC form to send to the beneficiaries?
So that's something that we will create. You know, it's the statute is really all it requires is that you send them notice of who the trustee is and who and how to contact that person. So sometimes I'll have clients and I'll say, okay, why don't you just in a family where everybody gets along, I might just say, here's I have a form email that I'll send to my client and say, share this with your siblings, you know, fill in your information, share it with your siblings and copy us on it. So we know that it's gone. Sometimes if it's, you know, people aren't close or there's other beneficiaries like charities or somebody who is entitled, then we have just a form letter that we will send out that is the MUTC notice. All right, so gaining access to trust assets. So the very important job, of course, when a new trustee steps up is getting access to the trust assets. So in these families' cases, while the parents were alive, they added their daughter trustees as trustees to the trust at that time. So why would they do that? Well, sometimes in situations, say where parents are getting on in age or they're not well, they will say, I really need a little bit of help managing my affairs. And so I'm going to add my successor trustee on as a current trustee while I'm alive, so that she can help me deal with these accounts and pay bills and make decisions for me or about the trust accounts during my lifetime, because I'm not quite feeling up to it. So that's what these families decided to do. They went to their lawyer, they added their daughters as co-trustees, and then they also took the next step, which is super important, is that they went to the bank and to their investment financial advisor and said, okay, we've updated our trust with another trustee, please update our accounts. That really helps things in many ways, because then when the parents pass away, if the successor trustee is already on the trust, it makes it a lot easier to simply update the accounts then with that new tax ID number that Megan mentioned before. Remember, when you have a trust that you've created during your lifetime, any accounts that you have in that trust use your own Social Security number. But when you pass away, your Social Security number can't be used anymore. So that's when we get this tax ID number for the trust. And it is the job of the trustee to notify each of the financial institutions where there is a trust account that the trustee has passed away, the grantor has passed away. That's the person who's created the trust, in this case, the parents, and that there is a new tax ID number. So in Carrie's case, she figures, oh, I'm already on the accounts. I'm just going to keep, writing checks and doing whatever I need to do. And she never notifies them that her parents have passed away. And the other thing that she does is she starts transacting in the investment account where there are marketable securities, stocks and mutual funds and whatnot. And so now she is selling things because she needs some cash. And she's doing it under her deceased parents' Social Security numbers. That's bad. It creates kind of a tax nightmare there, because one of the things that happens when a person passes away and they own appreciated assets like real estate or stock is that those appreciated assets get what's called a stepped up basis for tax purposes. So say the parents here each were brilliant enough to buy 100 shares of Google, 25 years ago for $100, and now that's worth $50,000. So if the parents had sold that stock during their lifetime, there would have been a very large capital gain tax payable, right? It's worth $50,000. Their tax basis is $100. They're going to pay a capital gain tax on that difference. But if they own that stock when they pass away, then the stock gets a stepped up basis, so that when it's sold, the gain or the loss is measured from the date of death. So in our example here, we'll say that it was worth $50,000 when the parents died, and then it got sold for $50,000 under that new tax ID number. So the gain there is zero. Unfortunately, with Carrie, there's still a stepped up basis when the parents died. The fact that she didn't update the documents doesn't mean that that's lost. But it makes it a very challenging tax reporting. Okay. Excuse me. So Now we get on to some more tax matters. Carrie, of course, thinks that she can take it all on herself. She does file her parents' personal income tax returns, their final returns, but she's not aware that when someone passes away, there are other tax returns that need to be filed. In particular, there's an estate tax return, which in Massachusetts is an M for Massachusetts, 706. That is a tax return that's required to be filed for estates where the value of the assets exceed the filing threshold. Currently in Massachusetts, that filing threshold is $1 million. There seems to be some traction to increase that $1 million filing threshold to 2 million or even 3 million. And, you know, everybody could help that along by making a call or sending an email to your state rep or your state senator to say, hey, you know, raise this amount. Massachusetts is the lowest threshold for estate taxes in the country. And of course, you know, we live in a region where our real estate is really high, and you know, people tend to have big retirement accounts and all of that. So a lot of people are paying estate taxes, including the careless family and the do-right family, because their estates, remember, were $1,750,000. So that estate tax return, that M706, is a return that reports the value of the assets that were owned as of the date of death. It is due 9 months from the date of death. And if there's a tax liability, that tax is due on that 9-month date. You can, of course, extend the return, but just like with your income taxes, you can extend the return, but the tax is still due. And in these families' cases where they have a $1,740,000 taxable estate, the tax due to the Commonwealth is about $81,000. Now, Carrie's failure to file that on time means that the clock is going to start ticking at that 9-month date for interest and penalties on that unpaid tax. And of course, as the trustee, it was Carrie's responsibility to get that done. So eventually, payment of those penalties and interest will fall to Carrie personally, not to the trust. Deborah, of course, consults with her attorney and accountant and all of that. Her attorney prepares the M706 and files it on time. Deborah has access to the trust assets. She hasn't distributed them all out, so she still has the money to pay the tax. And then in addition to the estate tax return, there can also be income tax returns due for a trust or an estate. And that happens when the assets in the trust or the estate earn money. So in this case, we've got some cash, we've got an investment account. And during the course of the year, while Deborah is administering the trust, those assets have earned some interest and some dividends. You know, maybe she sold the holdings in the investment account and there was a little bit of capital gain, again, measured from the value at the date of death. In any event, that needs to be reported. If the house is sold, that needs to be reported. So the trustee is required to file an income tax return for the trust, reporting the income earned on the trust assets. That's called a fiduciary income tax return. And for reporting purposes, federally, it's a Form 1041. And for Massachusetts, it's a Form 2. All right. Any questions on that?
I don't see any.
All right. So let's move on.
Perfect. So when you're serving as trustee, one of the biggest important things to do is to make sure that you keep your personal assets separate from the trust assets. You don't want there to be any commingling of the assets, and you don't want to be using trust assets for personal expenses or anything like that. We often recommend that you open a separate trust account through which you'll pay the expenses, and then you can keep track of it all coming out of that one account, and there's no confusion with your personal accounts. Carrie Careless here decides that she's going to use the trust assets to pay for the expenses of the estate, which is correct for her to do. But then she decides that she's also going to use those trust assets to pay for her own bills, which is a breach of her duty as the trustee. Because the trust assets are now paying for Carrie's bill, she's reducing the overall value of the trust for her own benefit. And that's unfair to the other beneficiaries. And then Carrie also decides that because no one else is using the house, she's going to rent it out to her friend, even though the house is owned by the trust. The rent is being paid from the friend to Carrie directly. There's no actual written agreement between the two of them because they decided, since they're friends, a verbal agreement is all they need. And that rent is being deposited to Carrie's personal account, even though that the real estate is technically a trust asset. And so any of that rental income that's coming in from the trust being rented should be going into the trust account, not into Carrie's personal account. Deborah DeWright, on the other hand, consults with her attorney and decides, yes, I'm going to open that separate account to pay the expenses of the trust out of, and I'm going to keep track of it that way. She uses those trust assets to pay the administration and estate expenses, but she keeps track of all of the expenses, all of the transactions performed on behalf of the trust. And that's going to help her later on when she needs to provide accountings to the beneficiaries and to say, okay, here's what happened, here's where we paid money out, here's where money was used for X expense. And then Deborah also knows that because the house, now both of her parents have passed away, the house is considered to be vacant. So she purchases vacant homeowners insurance, which covers the property while no one is living there. And she maintains the house using the trust assets, but does so from the trust as a whole so that everyone is paying the same amount towards the expenses of the house.
So one of the things that sometimes people will say when they're, in this role about the vacant house insurance that I will sometimes hear is, the client will say, well, that's going to be a lot more expensive. So I'm just going to leave that insurance that's there in place. And I will often say, well, why don't you just drop the whole thing then? Because if you have a casualty and you haven't notified them that the house is vacant, they're not going to pay. So either do it right or don't do it. But you, as trustee, you want to do it right, because again, if there's a casualty, the tree falls on the house or something, or somebody breaks in and nobody's there, and the insurance company uses the fact that it was a vacant property and they weren't notified in order to deny the claim. Well, who do you think the beneficiaries are going to go after? Well, the trustee, because it was her responsibility to make sure that the property is protected.
I think we have a couple questions.
Okay.
The fiduciary income tax return is for the trust's tax ID, is the first question.
Yes. That gets filed under the trust's tax ID number. And then the parents' final personal income tax return gets filed under their social security numbers.
The next question is the threshold of 1 million per person or per couple?
It's per person. So in our example, the parents could have done some estate tax planning where they had sheltered each that $1 million and wiped out the tax. But in our example for tonight, they didn't do that. So that's why we're saying, oh, one parent died, and now everything clumped up in the estate of the surviving parent. So say dad died first, and then 6 months later, mom died. Now she's got everything. There was no tax payable when dad died because everything that goes to a surviving spouse goes free of any estate taxes. But now mom dies and she's got the full 1,740,000. And so that's where the estate tax is being imposed. So, but going through that whole exercise, that's a topic for a different webinar.
The next question is, when filing an estate tax return, can brokerage houses provide a listing of the asset values as of the date of death?
They can, and they often do, but the IRS and the Department of Revenue require that marketable securities be valued as of the date of death using the mean value between the high and low on that particular day. So a statement from the brokerage house that says this is what the value is, at the end of the day, is not necessarily the correct value for the estate tax return. There's a software program that we use, that the taxing authorities use as well, and that I've actually seen some financial institutions, brokerage houses run those reports. Is the program's called EVP, and they've actually, some of them will use that program and provide us with that date of death value. But if they don't do that, then we just obtain those date of death values.
And then the last question, can the trust accounts be the ones used by the grantor before death?
Yeah, so in a revocable trust, these would be, like in our example, they had 4 bank accounts and an investment account, all titled in the name of the trust. So while mom and dad were alive, that was their money. They were using it. They were doing it. They were in charge of it. They were doing with it whatever they wanted. It belonged to them. So it was when they passed away, then now it must be administered under the terms of the trust.
Perfect. All right, so managing trust resources. So when you're serving as the trustee, you have to exercise reasonable care in your duties as a trustee. And part of that duty is to safeguard real estate if that's held in the trust. So Carrie here, she didn't obtain that vacant homeowners insurance that we talked about, and she didn't notify the insurance company that her parents had passed away. She also doesn't change the locks on the house, not knowing who has any keys, but decides that's all right, we're going to leave the locks as is. And she doesn't forward the mail to herself. She just assumes that the mail, she can go pick it up whenever she needs to. In the house, she finds part of her parents' tangible personal property memorandum, which lists that her mother wanted specific jewelry to go to specifically each of her siblings. Carrie notices this and decides that she doesn't want to go through the effort of doing that. So she takes what she wants and then she discards the rest of the items in the house. She doesn't give her siblings any chance to select any tangible personal property, and she doesn't give them any kind of notice that the items are being thrown away. So as beneficiaries, they have no idea that any of this is happening. And as a trustee, she is not taking reasonable care of the property. She's not going back to check on it. She's not exercising her duty properly there. Deborah, on the other hand, did obtain that vacant homeowners insurance, and she secures the house with those new locks. And she also forwards the mail to herself so that she's getting statements and bills and coming in. But she also goes and checks on the house regularly, both to pick up the mail and to make sure that the property is being maintained. When it comes to actually selling the property, Carrie just decides, whenever I get around to it, I'll put the property up on the market myself, and I'll just do it based on what I see the house is being sold for at that time. Deborah, on the other hand, invites 3 different real estate agents to come in and to give her different appraisals. And then she picks the best one, the one that is most advantageous to the trust. Deborah also finds the tangible personal property memo, and she distributes those items to her siblings with those receipts that we talked about earlier, saying, okay, we've received this, you are now released from that liability. Deborah also notifies her siblings in writing of her plan to sell the house, which is important because, again, you need to provide that kind of notice in writing. And then she also invites them to come and just split up that tangible personal property amongst themselves as they agree, which is what they were instructed to do in the first place.
So tangible personal property is always like a hot button, I find. It's easy to split the bank account 3 ways. It's hard to split mom's diamond ring. So this is really something that unfortunately families tend to fight over. There are ways to reduce that. We strongly encourage clients who have jewelry or artwork or musical instruments or just stuff that that your kids or other family members would like, to write down to whom those items should be distributed. Now, Carrie did a really bad job with that memo on which mom had taken the time to write down those items. But for the most part, when that memo is located, when families know that exists, they're going to do the right thing. They're going to do what's written on the memo. And that's really important because writing it down takes the controversy out of the family. This is what mom said. You're getting this, I'm getting that. That's the way it goes. Not all the time, of course, but it certainly helps a lot. And having a reasonable person in charge like Deborah, who is going to say, okay, guys, let's meet here on Saturday afternoon and, deal with all this stuff and see who wants what, is a good way to do that. So everyone feels included and no one feels like they didn't have an opportunity maybe to take the things they wanted before the 1-800 junk people come.
Any questions there?
Okay, so now we're ready to sell the house. Again, Carrie's looking after everybody by not incurring unnecessary legal fees. So she decides not to hire a real estate attorney. She can do this herself. But when somebody passes away, there are things that need to get done in order to sell real estate. And it's really important to have advice about doing that so that you don't get to the closing only to find that you don't have the documentation you're required to have. In particular, when someone dies owning an interest in real estate, there's an automatic lien by the Commonwealth of Massachusetts for possible estate taxes. And that lien remains against the property for a period of 10 years. So if the property is going to be sold within 10 years, that lien needs to be dealt with. There's 2 ways to deal with it, neither of which Carrie follows. So for estates like these that are over the $1 million threshold and an estate tax return needs to be paid, or an estate tax return needs to be filed and tax needs to be paid, then you obtain a release of the lien from the Department of Revenue, either by filing the return or by filing an application to get the release early if you're not quite ready to file the return. So that lien release needs to be provided and recorded in order for the title to the house to be clear. For estates that are under $1 million, where there's no return required, then the lien is cleared by the trustee or personal representative, if there's no trust, signing an affidavit that says there was no estate tax return that needed to be filed. And that affidavit gets recorded in the Registry of Deeds. Either of those methods will clear this lien from the property and allow the sale to go forward. But if you don't have that, you're not going to be able to proceed with the sale. So Carrie's in trouble there. She also, surprise, surprise, her friend decides that she doesn't really want to move out. And not only is she staying, but she's not paying the rent anymore. And she has changed the locks herself on the house, and she's causing all sorts of trouble. So now Carrie has to try to evict her, which is not easy or cheap in Massachusetts. So that's going to delay things quite a bit. And again, that liability is going to come back to Carrie, because if she has to spend $10,000 trying to get the friend out, and maybe there's an advantageous sale of the property that can't happen because the property is not vacant, Carrie's siblings are going to come back at her as the person responsible for those expenses, and they would be right. Deborah, on the other hand, of course, has done the right thing. She's gotten the lien release. She's filed the application to get it early because she's right on top of stuff, and the house is ready to go on the market in this hot spring market, within a few months of her parents passing away. And she's able to move forward and get the house sold using both her real estate attorney and her trust attorney working together to make sure all the documentation is in place before the sale. All right. Do we have any questions on that, Megan?
I don't see any.
Okay.
Perfect. So now that we have that bucket of, assets, now that the house has been sold, we're ready to make distributions, but distributions can be tricky because you want to make them fast enough that, the beneficiaries aren't getting impatient and questioning you, but also not so fast that then you don't have a reserve fund of those trust assets that Sue was mentioning for taxes or liabilities that could pop up later. And keeping that reserve fund means that you'll have money to cover those expenses if needed, rather than that falling to the trustee as a personal liability. So Carrie here, she paid herself from those trust assets as trustee without permission or notice. So she doesn't keep track of any of her compensation. She compensates herself at about $100 an hour, so way above that reasonable rate. And then she sells and liquidates all of the trust assets because she says, you know what, that's going to make things easier for me to distribute. So I want all the retirement account, any investment accounts that they had are now liquidated. All of those capital gains are gone. And then she fails to make any charitable specific distributions that she was supposed to make in the beginning. So now the trust asset as a whole is, not reduced by the specific distribution she was supposed to make. And now Carrie is distributing all of the remaining assets between herself and her siblings outright instead of in those trust shares. So she's losing that creditor protection, and she's distributed out all of the trust assets, leaving herself with no reserve fund should she need to then pay something later. If that is the case, it'll either fall to her personally, or she'll have to go back to her siblings and ask them to contribute towards the expense, which they're not obligated to do now that she's distributed the money to them. Deborah, on the other hand, does make those specific charitable bequests first before doing any other distributions. And she gets them to sign off with those receipts saying that she is now has made those distributions and is, released from liability to those charities. She does keep that reserve fund of trust assets because she knows, she's been told by her attorney, that up to 1 year from the date of death of the decedent, a creditor can pop up and, lay a claim to the estate. So here, Deborah is keeping that reserve fund. So in case something like that happens, or an unexpected expense or unexpected tax needs to be paid, she has those trust assets that she can use to pay that without having to then go out to the siblings and ask for money from them. Deborah also consults with a financial advisor about each type of asset and the best way to either invest them or distribute them or to put them into other accounts. Deborah then sets up the trust shares for each of her siblings that was supposed to be created after all of the distributions have been made. And then she helps, the attorney sets up the trust shares with their own taxpayer ID number, each trust share. So each child is now the trustee of their own trust share. Each trust share is reporting under its own taxpayer ID number. And now Deborah makes partial distributions of to the trust shares for her siblings, still not distributing out everything, but distributing part of the trust assets so they are receiving distributions.
Good. So just a couple of follow-up comments there. Under Carrie, we talk about her selling and liquidating the trust assets. In some cases, that's the right way to go. But in some cases, depending upon the structure of the estate plan, then that can create some capital gain. So we talked a little bit earlier, I mentioned how these parents could have done some estate tax planning, and they could have created separate trusts. So that's a very common plan where we've got the husband trust and the wife trust. So in that situation, say husband had died 15 years ago, and now his trust has assets in it that do not get a stepped up basis. And this happens a lot. So in that case, the trustee needs to be really careful about deciding what's going to be sold and what's not going to be sold, because that gain is going to fall to those beneficiaries. As an example, I am working on an estate right now where the husband died maybe 20 years ago, and had a nice investment account, which over the past 20 years has grown quite a bit. The advisor basically just let it sit there during the surviving spouse's lifetime. And anyway, there's now $515,000 worth of capital gain in that account. So if the trustee was not paying attention and just said, oh, just sell everything, that $515,000 of capital gain would have filtered down to the 3 beneficiaries who would have had to pick that up on their personal income tax returns. They probably would not have been very happy about that, because they would have had the option, which is what we ended up doing, of just taking the assets in kind. That means, say this was, whatever, 100,000 shares of Apple stock. They each took 330,000 shares, or 330,000, 100,000 shares of the Apple stock. And then each child can manage that herself. She can sell some when she wants to, she can hold on to it, but it's up to the beneficiaries then to decide if and when they're going to incur that liability. So that's why it's important to pay attention to what's going on. I just one other comment on setting up the separate trust shares for the children. So you're probably thinking to yourself, as Megan's talking about that, wow, that sounds complicated. And it certainly is not as easy as just saying, okay, kids, here's your, $1 million, take it and have a nice life. But the benefit of the little bit of work at this point to have it set up in trust is well worth the effort, because the advantages that it gives to those beneficiaries can be enormous. I mean, I've had beneficiaries who they were in bankruptcy, they were in the middle of a divorce, they were being sued from a car accident. So, receiving an inheritance outright in the midst of any of those events really jeopardizes that inheritance. All right, Megan, what happens next? A record keeping. Okay, so we've mentioned this on a number of occasions, but one of the primary duties of the trustee is to account to the beneficiaries for what she has done and how she's managed the trust assets. So we mentioned earlier on that providing the beneficiaries with an inventory, what's in this trust and what's the value of what's in this trust, and then tracking what has come in and what has gone out. So that's called a trust accounting, or for an estate, a probate accounting. And it's really important that the trustee do this on an ongoing basis, because it's very hard a year down the road to go back and open the checkbook and say, oh, I see I made a deposit of $5,000 6 months ago, but what was that for? I can't remember. So really keeping very good records, whether it's on a written check register, whether it's in QuickBooks or in an Excel spreadsheet. It's really important to track those. So Carrie, of course, doesn't do a good job doing that, but Deborah has kept all of these records simultaneously, and it's still work to put it together to do that, but she is able to provide her siblings with a complete picture of her administration of the trust, and her siblings are confident that what they are receiving is what they were entitled to receive, because they know what they started with, they see what came in, they see what went out, and they know what their share is. So a very important aspect of serving as the trustee.
So wrapping up. So now that the assets have been distributed into either outright to the siblings in Carrie's case, or in Deborah's case to the trust shares, they begin the process of, wrapping up the administration of the trust. Generally, we estimate that the whole process of trust administration takes somewhere between 8 to 12 months, barring any crazy things happening. So now that we've reached towards the end of that trust administration, each trustee's goal is to release themselves completely from any liability that they may have now from serving as the trustee. So Carrie here, she, as we were saying, pays herself out of the trust assets without keeping any kind of record or accounting of it, distributed those assets to herself and her siblings outright, and then she just assumes she's kind of done. She says, okay, well, the assets are with everyone. That was my job. And so she just says, all right, I'm done with my role as trustee, and kind of just assumes that everything has been completed. That's not the case. And so with Deborah, she knows that she still has liability serving as the trustee, and she needs to be released from that liability by the beneficiaries. So she, once the 1-year creditor period has ended, she distributes the remaining trust assets, and she receives receipts and releases from each of her siblings saying, yes, we have received these assets that we were entitled to, and we are releasing you of any further liability as the trustee serving for this trust.
So wrapping up, I think Megan was a little optimistic in terms of how long it takes. So yes, we might make distributions by like 8 months, 12 months, but there's generally a trailing income tax return that has to get filed for the trust. So, the trustee usually isn't done until that happens, which is a couple of months after the end of that 12-month period. So, if you're thinking about serving as trustee and thinking to yourself, oh, I'm going to be done in 12 months, you're usually not quite done, because you've got that tax return that needs to be filed. And the other caveat that Megan mentioned in that time frame is that without any unusual things happening. So what kinds of things can delay things? Well, if the real estate doesn't sell, or it doesn't get sold within that time period, and sometimes families are okay with that. I had an estate where they were all very friendly with each other, and one of the sisters was living in the house, and the rest of them were just like, well, you know what, she's going to stay there for a little while, and that was all fine. Everybody was happy with that. They worked it out. So the house didn't actually get sold for like 2 years or something. But so things can happen, and there is some flexibility. But yes, you generally really want to try to wrap it up shortly after that 1-year statute of limitations period has run.
Questions there? No.
Okay. So here we are, the results. So what happens here? So Carrie's got some trouble. She messed up on the tax stuff, and now she's working with having to pay penalties and interest, both for the estate taxes, and she didn't file the income taxes either. Her siblings are suing her for the money that she took for her personal use and for failing to account. And they're right. They would be entitled to, probably judgment and damages there. The house sale fell through because the market crashed. She wasn't ready to sell it. She couldn't get her friend out. She didn't have the lien release. It was all bad. Her sister Alice was in the middle of getting divorced when Carrie handed over her 1/3 of the estate. And Alice's husband was quickly there to say, hey, half of that's mine. So that's where that went. She didn't make the distributions to the charity, and the Attorney General in Massachusetts, it has a charitable division that watches out for charities and makes sure that they get what they're entitled to. So she's in trouble with the AG's office. And she gets audited for the tax returns being filed that she did end up filing and filing late. So all bad, all bad. Deborah, on the other hand, she's got everything distributed out. She's got releases from her siblings. Everybody's trust share is set up with their separate trust shares. The kids now go their own way. They're not linked together forever with this trust. They each have their own trust share, and once it's funded and separate, then they do their own thing. They make their own decisions about how it's going to be invested and what money they're going to take out. They can't put their own money into these trusts. Clients often ask us that question. Oh, okay, once I've gotten this trust share now from my parents, can I use that for my own assets? No, you can't do that, because the trust share from your parents is what's called a third-party trust. That means someone else gave you this money and they made the rules. And that's why you have the creditor protection. You can't take your own money and put it into a trust of which you're the beneficiary and then say, my creditors can't get at that. So you have to do your own planning for your own assets. She's all set with the taxes. She's filed everything. And she is truly done and can walk away knowing that she's done a good job. All right. And that is our do's and don'ts of serving as trustee. Any other questions that we can answer for you tonight? All right. Well, I think we're good. Thank you, everyone, for attending. We really appreciate it. If you have questions afterwards that you think of, please don't hesitate to reach out to us. We're here. And there'll be our next Smart Counsel will be in, not sure. We're August or September. And we're tentatively planning on a program with the local senior center to talk about benefits that they provide to the community.
One question, will the slide deck be available?
Yes. So what'll happen is that the webinar will be posted on our website with the slide deck as well. Yes. So that it'll take a little bit for our IT guy to put that together and get that posted. But yes, that you'll be able to find this on our website. All right, everyone, have a great night, and thank you again for attending. We really appreciate it.